Let's talk about a day that really shook up the entire digital economy. On November 19, 2025, a European court handed down a verdict that wasn't just another lawsuit. No, this was a landmark ruling that fundamentally rewrote the rules of the game for giant online retailers. So, we're going to dive into how this huge legal battle unfolded and what it really means for the future of the internet. You see, this decision from the European Union's General Court, it was a real turning point. It basically cemented a new digital constitution for Europe and set this incredibly powerful precedent for how big tech is going to be held accountable from here on out. And at the absolute heart of this whole legal saga was one central question. Is a massive online marketplace like Amazon just a simple store, a digital version of the shop on the corner? Or has its sheer size transformed it into something else, a systemic force that actually shapes our society, our safety, and our economy? That's the core conflict we're going to unpack. Okay, so here's our roadmap. We'll kick things off by breaking down the EU's new rulebook, the Digital Services Act. Then we'll walk through Amazon's high-stakes legal challenge and, of course, the court's final verdict. After that, we'll look at the ripple effect this has on other tech giants. We'll zero in on the two specific rules that Amazon fought the hardest. And finally, we'll explore what this all means for the future of how you and I shop online. So, what is this powerful new rulebook all about? It's called the Digital Services Act, or the DSA. You can think of it as the EU's really ambitious attempt to regulate the entire digital space, making a clear break from the more hands-off approach of the past. Now, central to the DSA is this concept of a very large online platform, or VLOP for short. What's so interesting about this definition is just how simple it is. It's not about what your company does, it's about how many people you reach. If you have over 45 million monthly active users in the European Union, boom, you are automatically considered a VLOP. And that means you're subject to the strictest set of rules. And this slide really illustrates the DSA's tiered or as asymmetric approach perfectly. The bigger you are, the more responsibility you have. It's that simple. Down at the bottom, you've got basic services with some light obligations. But as you climb that ladder to online platforms and then all the way up to the VLOPs at the top, the obligations become incredibly demanding. We're talking everything from systemic risk assessments to mandatory external audits. So, how did this new framework lead to such a high-stakes legal showdown? Well, on April 25th, 2023, the European Commission officially designated the Amazon store as a VLOP. This wasn't just some administrative label, it was a legal classification that kicked them into that highest tier of responsibility. And that set the stage for a massive fight. And this battle played out for over 2 years. After getting that VLOP designation in April 2023, Amazon immediately sued. And they actually scored an early win in September, getting a temporary suspension of one of the toughest rules. But that didn't last long. By March 2024, the EU's highest court reversed that decision and sided with the regulators. And all of that led to the final decisive verdict in November 2025, where the court completely, and I mean completely, rejected Amazon's case. So the crucial question is, why did Amazon lose so decisively? Well, it all came down to the failure of what people started calling the retailer defense. This quote really gets to the very heart of Amazon's argument. They were basically saying, hey, the DSA was designed for platforms like Facebook or X, places that deal with disinformation and hate speech. Amazon's point was, we're different. We just sell products. We don't amplify opinions, so you can't regulate us in the same way. But the court just wasn't buying it. It took that defense apart, piece by piece. First, it said the law is crystal clear. That 45 million user threshold is an objective number. Your business model is irrelevant. Second, and this is a real game changer, the court clarified that illegal content isn't just about speech. It also includes things like dangerous products, counterfeit goods, and unsafe electronics. Selling those things poses a direct, systemic risk to consumer safety. And finally, the court confirmed that any platform of this size gets treated equally because its scale alone makes it systemically important to society. Now, this ruling wasn't just about Amazon. It created a powerful precedent, sending a clear signal to the entire tech industry. And that ripple effect was immediate. You can really see that precedent in action right here when you compare Amazon's case to a similar one from Zalando, the European fashion giant. I mean, look at their arguments. They were nearly identical. We're just retailers, this law isn't for us. And in both cases, the court's finding was exactly the same. Your business model is irrelevant. Your scale is what matters. That objective user threshold is the only thing the law cares about. So, what were these specific rules that were so contentious that Amazon was willing to fight this thing all the way to the top? Let's zoom in on the two articles that were really at the heart of this dispute. On one side, you have Article 39, which requires a public, searchable database of all ads running on the platform. Amazon argued this would basically force them to hand over sensitive trade secrets to their competitors. Then on the other side, you have Article 38. This one requires them to give users an option for product recommendations that is not based on their personal data. Amazon's big fear here was that this kind of dumb algorithm would just lead to a worse user experience and ultimately fewer sales. In the end, the court sided with the EU on both counts. So when you put it all together, this ruling really ushers in a brand new era for online shopping, one where massive scale comes with massive, non-negotiable responsibility. I want you to remember this number, 45 million. This is now the objective black and white line in the sand. Once any platform crosses this threshold of monthly active users in the EU, it steps into a completely new world of regulatory oversight. So, what does this new reality look like? Well, first we're seeing the Brussels effect in full force. That's the idea that EU rules tend to become the global standard just because so many companies want access to the huge EU market. Second, the very idea of systemic risk has been redefined. Product safety is now legally on par with the risk of disinformation. And finally, the age of the algorithmic black box, it's over. These platforms now have to face mandatory audits and give researchers access to their data. The era of self-regulation is officially done. The principle is now firmly set in European law. With great scale comes great responsibility. The court has slammed the door shut on any argument that tries to separate a business model from its societal impact. So the final question really isn't if this will happen again, but simply which platform is going to be the next one to cross that 45 million user threshold.